Chris Irons, Director of Strata. That's stratasolve.com.au. Right alongside is Frank Higginson, Partner, Hines Legal. Frank, welcome.
Hello, Chris. Hello, everyone. Yet again. I say that every week. I need a new starting line.
It's a challenge coming up with fresh material. But there it is. We're up for challenges. Just usual housekeeping stuff, folks. If you are new to the show, and shame on you if you are, but if you are new to the show, we live stream to YouTube and Facebook every Thursday at 2 o'clock Brisbane time. So to follow on Facebook, you go to the Hines Legal page and hit the like button and icon. And for YouTube, hit the subscribe button and the notification bell. Very much appreciate comments fired live at us, keeps us on our toes. We'll try and get to as many of those as we can. If your inquiry is a bit more involved, better that you put your details into the form, which will be coming up as a link very shortly in the comments field in this chat. Today, one of our very, very favourite long-time viewers / listeners, KJ, if you're out there, thanks very much, KJ, has suggested this week's topic, and we think it's a great one too. Frank, this idea of unofficial committee communications.
Back-channeling. Body corporate records. Committee decisions that aren't formal. Finding out what's actually going on. It's a really... and interestingly enough, I suppose, we had a couple of hits. And certainly, I suppose this is the joy of the flexibility that we have with this in terms of the Chris and Frank show. We can put a webinar on a week's notice with no problem at all. But a couple of these rolled in around the same time in terms of, well, if the committee is having conversations, if the committee is doing body corporate business and it's not part of the body corporate records, can that happen? Should that happen? What should happen? How does it get caught up? So it's a really interesting thing. So today, I think for both of us will be could be a little bit provocative on both sides of the fence, because it is that, we come back to this all the time in terms of these conversations: transparency, accountability, visibility, in terms of body corporate decision making and body corporate affairs generally. So if things aren't on the record, that's not necessarily as transparent as things might be. So I suppose, Chris, one of the things today really is there such a thing as off the record committee business, or is it all on the record?
Well, let's delve, Frank. Let's delve. And we seem to talk about this every week. The idea of politics and Strata being almost one and the same thing. I think that there's very much a political aspect to this as well. We all know, for those of us who take an active interest in government and politics, that things happen in politics all the time that are off the record, and arguably that's actually where the decisions get made. Can the same thing apply here in Strata? Let's have a look. I think we probably need to go back to a few first principles though, Frank. What is it that a committee is actually supposed to do?
Make decisions. And I suppose if you come back to the core of it, it's sort of, there's nothing legislative about what you and I might do or not do in a business sense. In a body corporate perspective, particularly when it comes to committees, there's a relatively tight framework in terms of what their roles and responsibilities are, and limitations in terms of what they can and can't do. So spending limits might be the biggest example of that. You can't spend more than X dollars per lot. Restricted issues, committees can't make decisions on things that are restricted issues, things that change the rights, privileges and obligations of owners, commencing a legal proceeding other than a Chapter 6 proceeding in the Commissioner's office, things that are reserved for decisions at general meeting only. But other than that, I suppose, and obviously, that's obviously a fairly large swathe of what a body corporate might make decisions on. But outside that, it's really a committee's obligation is to act reasonably, and its sole function really is to make decisions reasonably in relation to the affairs of the scheme.
Yep, that's it in a nutshell, Frank. You're absolutely right. In getting to that point of decision making, then that's probably more where we're focused today. That you're getting. So absolutely, a committee should discuss, deliberate, debate, and do so robustly, God knows I've sat in on a few meetings where there have been some, and I know you have too, Frank, some really robust intra-committee discussions. Committees can also form subcommittees too, so that's absolutely. You can have an informal committee meeting, but we'll get to that shortly about the issues around that. Committee members absolutely can chat, have a bit of a hack, but at the end of the day, upon minuted, and that's really it. Which is where we get into the topic of body corporate records. Frank, let's do a bit of body corporate records 101 because it's really important for the context of this discussion. What have we got on that one, Frank?
Well, I suppose they're very heavily litigated things, and the easiest thing in the world is to link, which we'll do, part of the Commissioner's Office webpage, which talks about it a lot, and also the webinar that you and I did on body corporate records some time back. So, and effectively, I suppose you'd say a body corporate record is the corporate mind of the building recorded in writing. Because there's no way to know what's going on other than by the records when you're really an interested party. So we've conversations about those previously, who wants to know what's going on in the body corporate. So that interested party might be a lot owner, might be a prospective purchaser of a lot, whatever it might be. But the records, or the record keeping and the record, I suppose, recording obligations in the legislation are designed so that interested parties can get visibility on what's going on in that particular body corporate. And really, I think probably the starting point is it's almost anything in writing relating to the affairs of the building as a whole. So clearly, and I mean, one of the conversations that comes up all the time from a body corporate manager's perspective is this email a body corporate record? And the easiest answer to that usually is anything sent to the body corporate manager in relation to the affairs of the building is going to be a body corporate record, because there's no other basis for them to hold it other than who you're backing in the fifth at Doomben on Saturday, which clearly it doesn't relate to the affairs of the body corporate as a whole. But other than that, it's those sort of things. And there's gaps there in terms of how long you've got to hold certain things, 2 years and 6 years. Won't go into all of that today, but I suppose the default position, and certainly where it gets to from an adjudicator's side of things, because they can be fairly robust, again, for no better phrase, in terms of record keeping from bodies corporates, is if a body corporate doesn't have a record or isn't going to supply a record, it's got to be on fairly solid grounds as to why it's not going to do so before an adjudicator will sanction that not being available.
I guess that's what we're driving at today, isn't it, Frank? This idea of saying you want something to be confidential. Okay, well, on what basis do you want it to be confidential? And is there anything to support the idea that you want it to be kept confidential? So you just talked there, Frank, about adjudicators' decisions. Let's delve into a little bit of that to back up what we are talking about. As Frank highlighted, and 100% agree, this is an area of strata law determination where adjudicators can get pretty, I was going to say uppity, that's not quite the word I was after. Direct is probably the word. And I think, Frank, the reason why, and you said this at the start, it's such a fundamental part of living in a community title scheme. It usually is the basis for anything, including dispute, is the record. Does it exist? Can you access it? Does that tell you what you need to know? Information is power, all that sort of thing. What have we got, Frank, in terms of relevant orders here that help us out a bit?
Well, probably we'll put up some links to these. So I think probably, and Ostley is littered with them. So if you go and hop in and start searching body corporate records, you'll see plenty. There's one very notorious one, Chris. We won't name names on this one, but where a body corporate manager got fined 20, 25 grand. I can't remember the number now, for not handing over body corporate records despite an order from an adjudicator to do so. So I think for those of you that have the time and the inclination, have a look at the Grange, which is a link to a decision from 2018. We'll put up here, and it'll be in the show notes later on. And that's more about a body corporate taking forever to produce copies of records and saying it's too hard to find and we've got to go back time to find them and all that sort of stuff. And the adjudicator said, you know what, I don't care. And owners don't care because the Act says you've got to do this and you've got to do this. But I think probably for the purposes of today, there's two other decisions that I think are pretty relevant as we delve down into what is unofficial correspondence or off the record correspondence. So the first one is Q1. So obviously very large building on the Gold Coast from 2013 was this decision. So Q1's got a lot of decisions in the Commissioner's office. And I suppose with 500 odd owners, you're going to have that capacity. Mm-hmm. And this is really about whether a record or who held the record and whether it was a body corporate record. So the adjudicator here said that a relevant document becomes a body corporate record when it's created or received by or on behalf of the body corporate. So on behalf of the body corporate is not by the body corporate manager, it's on behalf of the body corporate. So if it arrives to you, this is as a committee member, it's a body corporate record. So the adjudicator said in my view, where documents are required to be kept by a body corporate and held by an agent of the body corporate, then they form part of the record. So communications sent to or from committee members representing the body corporate that relate to committee business are body corporate records, even if they're not included in the official files. So Chris and I are both on the committee. We're emailing about this difficult owner, KJ, we've got, and how much of a pain in the backside he is, and why we might actually go and make a nuisance application against him in the Commission's office to shut down his voluminous correspondence. That would be a body corporate record based on that interpretation, even though it doesn't get copied into the body corporate manager at all. So the other decision, so that we'll put up a link to that, and Carmel by the Sea, which is another very famous Gold Coast building, that spoke about body corporate records in this context as well. And it's along the lines of there may be informal communications between committee members that aren't of a character that comprise a body corporate record, but if there's email exchanges that relate to committee business, it's likely that they are records. So email exchanges about personal opinions on a matter that might be voted on at the next meeting may not be a body corporate record. So it's really interesting. The characterization of the type of communication is a real big part of what forms a body corporate record. And I suppose looking at those two decisions, what I'd be saying, it's really about the purpose. What was the purpose of that communication? Is it to talk to Chris about what we're doing on the weekend, or is it to discuss the affairs of the body corporate in both of our capacities as committee members, as opposed to lot owners? So, you know, and obviously there's some grey that can appear in that across the board, but I think so there is some wiggle room, is what I'd be suggesting, and that comes down to characterisation, comes down to purpose, and purpose can sometimes be a little bit subjective. But it's interesting, and I suppose the key thing is what we're talking about today, is emails between committee members can and may well be body corporate records and should form part of the body corporate records. And here's one of the flaws in the system, I suppose, is our body corporate managers get 40 million emails a day. Are we going to make that 42 million? When they're replying, everyone's replying all that everyone, the body corporate manager might or might not be involved, because they're traditionally the keepers of the conch, aren't they? Yeah. That's where these things go. And certainly, we come back to education and all that sort of stuff, Chris. As sure as I'm standing here today, I'd suggest the vast bulk of committee members in Queensland don't necessarily realise that emails between themselves about body corporate issues probably are body corporate records based on those two decisions I've just been speaking about.
I think a good rule of thumb there, Frank, might be if you are claiming that a record is not a body corporate record, well, why not? You need to have a lot more justification than simply, well, because it's confidential. That of itself is not going to cut it. And if you, those orders that Frank has specified, there's a pretty good discussion on the concept of confidentiality in there as well. A couple of questions have come in, which we will get to. Thank you for those. Keep them coming, everyone, if you get the opportunity. Some of what we're about to talk about next touches upon those. So this is the idea, Frank. What happens outside of a committee meeting? So we established just before that the point of a committee is to decide upon things as per their legislative requirements. The way in which they are meant to do that is by meeting, because in order to make a decision, you have to meet and then decide. But of course, Frank, it is very, very common for decisions to be made another way outside of a meeting, isn't it?
flying minutes, votes outside committees. VOX, I suppose, is the acronym that we all use. Very common. And so I suppose when you come back to, again, transparency and accountability, the intention, and all of the modules are really consistent about this, is if you're going to have a committee meeting, owners must be able to attend on giving 24 hours notice. They can bring, not necessarily a support person, but someone else with them who's not associated with the scheme. So there is transparency in terms of committee decision making in meetings. People can be asked to leave if they're the subject of that discussion, but other than that, away we go. So I wrote a newsletter 1,000 years ago about Clayton's committee meetings, where there was just an adjudication decision that sort of just grabbed my eye, where an adjudicator said, VOX are fine, but they shouldn't be used as a way to avoid accountability or that transparency and those sort of things. So, so we do have lots of decisions outside committee, and again, in, I suppose, 2 years of COVID as one reason not to meet physically. There are lots of valid reasons to have things decided on the fly without getting together in formal meetings. But by the same token, certainly where the legislation adjudicators seem to drive is big ticket decisions. You've got to be really careful about, again, the temperature of the building in relation to specific issues. And again, and this is the difficulty with these things from a outsider's perspective, is if there is a particular point of contention, the committee members can be having beers, nattering away, chatting about all the things that are going on, because one thing that isn't a body corporate record is conversation. So if we're going to be chatting and there is no written record of things, and decisions and aspects of what we're going to do are being discussed there, and then we go to a committee meeting for a particularly contentious issue and vote 6-1 that's it without discussion, then that is a hard thing to challenge from an outsider's perspective. So that's, it's sort of, and again, I suppose it's difficult, ladies and gentlemen, for Chris and I, because I mean, we act for everyone in these spheres. We act for committees, we act for lot owners, and there's games to be played on either side, but that is one of the things that is the reality of legislation. A conversation is not a verbal record. A WhatsApp chat is.
That's right.
If we're back to the purpose of those sort of things.
And probably just to pick up a point there, Frank, I think sometimes there's this idea out there that a VOC is a bad thing or a sinister thing in and of itself. And I think it's just very briefly touch upon how in other forms of corporate governance, that idea of deciding things outside of the formal meeting is pretty commonplace. I personally am on the executive of 2 not-for-profit entities, very different ones, but I'm an executive of 2 different ones. And outside of meeting decisions are almost a daily occurrence in those organisations. And it has to be, because everybody's got a day job. Everybody's got 50,000 trillion other things that they're doing. The idea that you have to meet and decide, that it's a bit of a pointless endeavour. Nothing would ever get done that way. So this idea that something is inherently wrong with a VOC, no. It's about, as you pointed out, Frank, how those VOCs are used, and are they being used in a way that disenfranchises people from their right to exercise oversight and be part of the process. A few questions are coming in along those lines, which we will get to. So obviously that's a bit of a trigger point, that one. All right, so let's get to it then, Frank. This next section, a lot of people will be interested in. A lot of people won't be entirely pleased either, but we're going to do it anyway.
Yeah.
If a committee wants something off the record, Frank, what do? They
talk. They talk. And this is one of the interesting things. If you go back, I suppose, 20 years, not that, well, if we went back 20 years, we wouldn't be doing presentations in this way. We'd be doing them physically, talking to people in groups, and all of us would also be communicating that way, because 20 years ago, 2002, no, we did have email then, maybe 30. Let's go back 30, before we had desktops on our desks. Fancy that. You'd catch up and talk. Committee meetings would be talking. You'd be talking to people. You wouldn't be sending emails. You wouldn't be sending texts. You wouldn't have group chats. We didn't have social media. None of that stuff exists. So I think if people are chatting, as I was talking about before, that's not a body corporate record, and there's very little that anyone can do about that. So from a committee perspective, if you don't want to be accountable, this is it, black and white. You have chats, you get together, and then you make decisions without justifying them to people. And then I suppose the difficulty is to prove that they're reasonable, because one of the things that comes with proving a decision is reasonable is laying out the rationale for that decision in itself. And if there is no rationale and there has been no discussion, then it's not necessarily automatic that it's not a reasonable decision, but it certainly creates a little bit less defensible in the sense of that's it, that's happened. No ifs, no buts, no maybes. So again, there's a balancing exercise there, and this is the grey which we both play in terms of what is reasonable.
I think technology can absolutely be your friend if there's a desire to have something kept confidential. You might want to investigate what is available to you in terms of apps or automated systems where the committee can conduct, for example, maybe a non-binding poll. So the idea of committee members actually discussing amongst themselves, how do we think that we're going to vote in a particular way? I'm thinking this, I'm thinking that. Maybe that's a good way of actually establishing some common ground, or whether some further work is needed on a particular issue. Use Zoom or Teams, but don't record it. It's probably the message there. The instant you hit record, that's going to be a record. I personally think it's really important to be pretty honest with yourselves to the extent that you're able or willing about your reasons for wanting something confidential. If your reason for wanting something confidential, there's a tangible commercial issue at play, well, that's possibly one thing. But if your reason is because you actively want to exclude another person from the discussion because you just don't like them, and there's a history of bad blood between you and that person, that's where it gets a bit more problematic, doesn't it, Frank?
It does, because you can't do that when they're on the committee. And that goes on a lot. It does go on a lot. There's people that get left out. And I suppose that leads to the mole conversation, doesn't it? And one of the reasons they can get left out is we're back to factions. We're back to different points of view. We're back to, there's 5 of us that are with Team A. There's 2 people that are with Team B. And we know that Team B are leaking to the people that are our opponents that aren't members of the committee. But what can we do about it? And the reality is there's not much, because they're members of the committee. You know, and this is, I suppose, there's no...
You can have a stern conversation, Frank. I think you can absolutely do that. I've had that with some clients, and I've said you need to be speaking as a united voice. It doesn't matter if you disagree. Disagreement can be really healthy. That's fine. Once the decision is made, though, that's the decision. And you need to be united on the fact the decision has been made and it will be carried out. So I think there's absolutely scope for stern discussions to be had about that. Sorry, Frank, interrupted there.
No, you're right. No, not at all. It's sort of like talking about cabinet solidarity. You see that in federal politics, but again, they're paid $300,000-400,000 a year. They're accountable to their factions, whatever it might be. Dare I say, Chris, you've been a little bit idealistic in terms of cabinet solidarity applying to a voluntary position like this.
Fair. There are some really good questions here, Frank, which I think we'll pick up on a few more points, actually. So we might rip into some of those in the short time that we got left. So Thurston, you're becoming a bit of a regular. Thank you. Thoughts on asking owners to use a Gmail account that doesn't, I imagine, get included in body corporate managers' searchable records? I'm thinking that you're saying there that people are being directed to use a specific Gmail address for committee business, maybe. I'll make that assumption anyway. It's still a record, regardless of the type and the platform. And there is a very, very, very infamous public case of this happening in the Queensland government, of course, the whole Mango Q affair. If you really want to know about how confidentiality is or is not done, that's a really good example. But Thurston, I would suggest it's still a record. Doesn't matter if it's a Gmail address.
Agree.
Bryce, thank you. Is a VOC decision legal if all body corporate members were not given notice of the matter being discussed by the committee? I'll give this one to you in the first instance, Frank. I suspect we might have slightly different views.
As lot owners, look, I'd look at which module you're under. So accommodation module means a VOC's done, basically. Standard module, there's a period of time in which owners can object to it. So, but again, with these technical things, I always say it's a matter of, even though it might technically have not met with the rules, that's usually not a ground on which an adjudicator is going to knock something on the head from a validity perspective, because they're going to look at it and say, well, would it have happened anyway? And if the answer is yes, then they're not going to knock it over. So we see that with ratification decisions. Like sometimes, like a committee of 7, 5 people vote yes to something, 2 weren't given. The two moles weren't given an idea that it was coming. If 5 have voted yes and 2 didn't even know it was happening, it's still going to be passed at a committee level no matter what. So usually an adjudicator won't invalidate the decision made on that basis because the numbers were there regardless.
Yeah. Pandanus, thank you. Our body corporate committee has sent us some motions to vote on and suggest to us to not vote for motions 5 to 6, but vote for motions 2 to 4. That's okay.
They're entitled to an opinion, I suppose, and you could go back and look at the decision making behind that. But with those things, always it's a matter of trying to deal with the contest you've got before you, because if you've got a general meeting, it's going to be on in a couple of weeks rather than try to belt the committee around about invalid decision making. But committees, as well as owners, as well as resident managers, can write to owners and say, hey, I think you should vote for this and against that. Completely legal.
Absolutely. Sam, thank you. Our committee makes R&M decisions and are minuted, but then do something completely different, not like for like or anywhere near it. Should this be an owner's decision? What's R&M, do we think, Frank?
Repair and maintenance. So I think we're talking about maintenance versus improvements. So there's a webinar that we did a little while back. That is probably worth watching. But ultimately, that's a characterisation thing again. If it's an improvement and it needs resolution at general meeting to do it. So it wouldn't be probably the first committee that's characterised something as a replacement and as maintenance when it actually is an improvement. But then do you want to stack on that blue and what's the evidence and all that sort of stuff? But have a look at that webinar on maintenance versus improvements. That covers that question specifically.
And then your follow-up question, Pandanus, is actually the same issue, I would think. Would fixing a spa or pulling it down be a reason for a VOC? I think that webinar as well would be quite useful for you.
Fixing is maintenance. Pulling it down, believe it or not, is an improvement from a legislative perspective.
Yep. Sam, this one's probably for you, Frank.
Yeah.
Thanks, Sam. If Hines have acted for a body corporate, is this a conflict of interest and prevents you acting for a group of owners in that building?
Only if we've got confidential information that could be used to the detriment of our former client. So one of the big things that is not understood with respect to conflicts of interest, just because we've acted for someone does not mean we can't act against them. What we can't do is have in our possession any confidential information that could be used. So, and in a body corporate sense, that's not all that common. If the issue is relating to the same dispute we advised on, then definitely potentially. If it's something brand new off the bat and we acted for the building 4 years ago and it's a completely separate issue now, usually not. And dare I say it, I'm a commercial creature, so the problem, as Chris would know, if I'm not acting for you, I'm quite happy to act against you, is the unfortunate reality of the situation, because I've still got bills to pay as well. So
it's a reality.
Yeah, so reach out if you want us to have a look at something and I can tell you whether we are conflicted or not.
And one final question, Mr. SMB, I know a bit of a regular, thank you. What if the talk is recorded, audio of video? I suspect that would be a record. Frank?
Yep, agreed. Same as CCTV is a record, well and truly. As much as the legislation doesn't refer to audio-visual recordings, to me, we're back to the purpose. If we're having a committee Zoom discussing committee issues, then that is no different to me in a sense to an email exchange.
And it's also tangible too, isn't it, Frank? The difference between the discussion and the recording is that one is tangible. It's there. So, all right. Gosh, we've come right to the end. Really quick wrap up. If you are new to the show, don't forget we live stream to YouTube and Facebook every Thursday at 2 o'clock Brisbane time. So to follow us on Facebook, go to the Hines Legal page and hit the like button and icon. For YouTube, hit the subscribe button and notification bell. There's a lot in that discussion today. There's a bit there, I think. We might see about where we go to with this sort of thing in future. But for now, Frank, thank you, as always.
Thank you, Chris. Thank you, everyone. And just one last question. So from Thurston Howler Force, so can they delete the record? Well, they can, but they shouldn't.
Yeah.
There you go. So yeah, sorry to cut you off, Chris. Yes, thank you, everyone, yet again, and thank you, Chris.
Thanks, everybody. Much appreciated as always. We'll see you next time.
Bye.
Bye-bye.